In an important development, the Supreme Court today issued notice on the petition challenging the order of the Gujarat government allowing the premature release of 11 convicts sentenced to life in the Bilkis Bano case for gang rape and murder. A bench comprising Chief Justice of India N.V. Ramana, Justice Ajay Rastogi and Justice Vikram Nath, however, posed a query with respect to the legal bar on grant of remission to the convicts. During the hearing, Justice Rastogi asked Senior Advocate Kapil Sibal, appearing for the petitioners, as to whether it is sufficient to say that the remission is wrong merely because the act was horrific. Significantly, Justice Rastogi and Justice Vikram Nath were part of the bench which had ruled back in May 2002 that the Gujarat government has the jurisdiction to decide the remission in this case. Justice Rastogi further inquired from Sibal, and I quote here, "Day in and day out, remission is granted to convicts of life sentence. What is the exception in this case?" These observations were made while the bench was hearing a petition filed by CPIM leader Subhashini Ali, independent journalist and filmmaker Revati Lal, and Professor Ruprekh Verma. To provide a brief context for all of you, as India celebrated the 75th anniversary of independence on 15th August, 11 men sentenced to life imprisonment for the gang rape of Bilkis Bano and the murder of 7 of her family members, including her 3-year-old daughter, in a communal attack during the 2002 Gujarat riots, were released from jail in Godhra. Bilkis was the only survivor of the crime. The investigation was subsequently handed over to the CBI as per the directions of the Supreme Court. The Supreme Court had also shifted the trial to Maharashtra. In 2008, a Sessions Court in Mumbai passed the sentence in this case. As the 11 convicts walked out of prison on 15th August, they were welcomed with sweets and garlands. The Gujarat government said that it had relied on its old remission policy of 1992 to approve their applications for remission of the sentence and not the current policy of 2014. This was done after the Supreme Court in May this year, while hearing a plea filed by one of the convicts for premature release, had held that the Gujarat government was the appropriate government to consider the remission in this case, and had accordingly directed that the remission applications have to be decided within a period of 2 months. The Supreme Court had also directed the Gujarat government to consider the application for premature release under the policy dated 9 July 1992, which was existing at the time of his conviction. You can refer to our earlier video where we have explained the case and the timeline of events in detail. The link to the video has been provided in the description box below. Today, at the outset of the proceedings, Chief Justice of India N.V. Ramana clarified that the May 2002 order merely held that the remission or premature release in terms of the policy which is applicable in the state where the crime was committed has to be considered. The CJI remarked, and I quote him verbatim here, "I read somewhere court has granted permission for remission. No, court said only to consider." The bench then issued notice in the matter and directed the petitioners to array the accused persons, the affected party, as respondents in this case. During the hearing, Sibal narrated the grim facts of the case relating to the exodus of the Muslim population, rampant incidents of rape and murder. However, the bench asked Sibal to confine himself only to the issue of remission. Whatever they have committed, they have been convicted. The question is whether they are justified in considering remission. We are only concerned if remission was in the parameters of law, Justice Rastogi said during the hearing. The counsel appearing for the state of Gujarat, on the other hand, opposed the petition on the ground of maintainability by stating that the petitioners are mere strangers. The court then asked the state to file its reply and listed the matter for further hearing after 2 weeks. This is Aratrika Bhomik for LiveLaw. Keep watching LiveLaw for more such updates.